We are live.
Great. Thank you all for being here. I wanted to convene this informational hearing just because we are going to be looking to get this bill out of committee, the Aid in Dying bill from the Public Health Committee tomorrow. And with us today, we have a number of speakers who I will introduce themselves as we go. We'll give about 5 to 10 minutes for each speaker. And then at the end, if anybody has questions, we'll be taking questions. And to kick this off, we have the chairman of the Public Health Committee, Representative Steinberg, here with us to give a few comments.
Thank you, Representative Elliott. I will not be taking 10 to 15 minutes, I assure you. As Josh mentioned, we will be taking up this bill in committee tomorrow. It is not the only controversial bill we'll be taking up tomorrow, but to my mind, this is a very important juncture for this committee and for this state. We have discussed legislation much like this now going on 8 years. And I submit that the world has changed in that time. Not only do we have so much more understanding about the medicine, the science, we have experience in Oregon and now 8 other states in the District of Columbia. And I believe that the moment has come for the people of the state of Connecticut to accept. They may not embrace, they may not get excited about having to deal with end of life for anybody because it's really harsh. And we've been living with that in the pandemic. But I'm hoping we've reached a point of acceptance. What we're talking about is a very small group of people who are in real duress. They're in an end of life circumstance that involves pain and suffering in a fashion that we would not wish on anyone. And all we are asking is to afford them the choice to end life on their own terms. Ideally with their families in a loving environment, but based upon what their wishes are, not that of the medical community, not that of their anybody else, insurance companies, anybody else who might have a vested interest, but that individual's choice to end life on their own terms. This bill is really not new. It is patterned on bills we've introduced in the past that exist as the framework for existing law in other states. They're rigorous. They have many safeguards. Some would argue perhaps too many to actually afford people the realistic prospect of being able to avail themselves of it. I'm hoping that tomorrow that the committee members will step up and afford us the chance to take this out of committee and to vote on it the floor of the House and the Senate, where I do expect it will pass. We can expect that tomorrow it will be divisive and contentious. And that's why an informational forum such as that Josh is sponsoring here today is really important. A lot of the things that were said at the public hearing on Friday are speculative, argumentative. They are based upon supposition and not based upon fact. They assume something in the future which will never occur or is unlikely to occur. And I really welcome the opportunity today to hear from people who understand what we're talking about, who can put the facts on the table, disabuse those of myths and misconceptions, and really put this all in context about who we're talking about, what we're asking for, and to deal with the thorny issues of ethics and dignity that we feel are central to what we're trying to accomplish here. So again, thank you all for participating today. I'm hoping that this information will be widely disseminated so that not only those on the committee, but those in the legislature and more broadly will begin to understand how important this legislation is. Thank you, Representative Elliott.
Thank you, Chairman Steinberg. We appreciate that. And with that, let's kick it off with Lori Bruce. And why don't you introduce yourself and then let us know what your thoughts are.
Thank you so much. My name is Lori Bruce, and I'm an ethicist and policy analyst at Yale's Interdisciplinary Center for Bioethics. I also teach health policy and ethics grad courses at Mount Sinai School of Medicine. And I'm going to share my screen I have some slides to engage us today. Can you see my slides?
Sure can.
Okay, wonderful. I just need to move these windows to get us ready. Okay, thank you, members of the General Assembly, for inviting me today, and thank you for your service to the state of Connecticut. For decades, I was not in favor of aid in dying, but my views have changed, and I do fully support this bill. So in recent discussions, some folks have raised concerns as to whether aid in dying is contradictory to a physician's duty. It is not confusing for a physician to promote life, but also to promote aid in dying. A physician's role, after all, is not necessarily to help extend a person's life as long as possible. It is rather to provide care that is in line with the patient's values. A wise ethicist once told me that physicians are experts in medicine, but it is patients that are the experts of their values and preferences. And it is also the duty of a physician to provide compassionate care. We consider palliative care physicians who help patients die comfortably every day in Connecticut hospitals, commonly or often through the administration of medications that may make them sedated or unconscious, and taken out of context, that may seem concerning or troubling. But the process of helping, of providing these drugs to provide unconsciousness or sedation is not abandonment. These physicians are not withdrawing treatment. They may be withdrawing the treatment, but they're not withdrawing care, because palliative care is good, kind, ethical care to prevent anxiety and to prevent pain. Similarly, when a patient is dying at home, unable to receive inpatient care, and requesting aid in dying, a physician should likewise provide caring solutions that manages their anxiety and pain at end of life, and not abandon them to a painful or anxiety-laden experience. Another question that has come up over the past week is related to how some physicians were testifying that it may be impossible to fully chart out a patient's disease progression and accurately diagnose whether a patient really does have 6 months to live. So there were some worries as to whether aid in dying could prematurely cut their lives short. Well, we all know that prognostication may not be an absolutely perfect science, but when we look and consider how hospice works today, we know that hospice is permissible when a patient has less than 6 months to live. This marker of 6 months is not contentious or controversial here in Connecticut, and today we are not here debating that marker. And we know that in our state, only 7% of hospice patients live over 6 months. So we already see that in Connecticut, physicians are really good at prognostication. Another question that has arisen over the past week is who should be initiating aid in dying? Some say that physicians should be the ones to decide whether aid in dying should be legal, and that we should not be here today making this decision. That's not correct. Aid in dying should be initiated by the legislature, by the people. People often look to legislators to help them gain back some control from other communities, including the medical community. And in fact, this is part of the birth of bioethics as we know it, because it was not so long ago that the majority of physicians considered it abandonment to take any patient off of a ventilator, even when a patient had no chance to regain meaningful consciousness. It was a confusing time, and yet people had to go to the courts to gain back control from medicine. And similarly, this aid in dying bill seeks to reclaim some control over dying at home. Every day in Connecticut, patients are making choices that their doctors may not agree with, about perhaps reproductive care, or perhaps whether to take the less effective but cheaper medicine that their insurance will cover so that they can keep food on the table. And so forth. This happens every day here in Connecticut. And as long as the patient has capacity, it's their right to make these decisions. Every day in Connecticut, similarly, patients will make choices to forego some amount of life to transition to their dying process. Aid in dying is not unique in its ask to end someone's life a few days or weeks or months before the body will finally fail. When we look at other current legal and accepted pathways to death, we see that many choose comfort care or hospice, even though a more aggressive approach could add perhaps weeks or months to their life. This is not widely debated. This is not controversial. My slides are disagreeing with me here. Let's see if I can move this. Okay, patients also have the right to stop dialysis. You may know that dialysis can be intense and hard and painful, and some patients really don't like living this way. Indeed, a quarter of deaths in patients with advanced end-stage renal disease are from choosing to stop dialysis, knowingly ending their life. This path is understood. It's not widely debated or controversial, even knowing it can take weeks or months off of a person's life. And as some people age, they are ready to have their cardiac implant removed. The technology that once helped them to stay alive is now still functioning, even when the rest of their body is not. In fact, we know that 92% of physicians who manage patients with cardiac implants have deactivated an ICD, and 77% of those physicians have deactivated pacemakers. This path is widely understood. It's permissible, even though, again, it may curtail weeks or months, or perhaps in this case, even years off of a person's life. And I thought it may be an interesting note that it's not necessary for these patients to be terminally ill to make these requests, because it's already well established that a patient who has competence has a legal right to request the removal of their cardiac implants at any time. So we know that life isn't just about eking out a couple more days sometimes. People want to be able to have a say over the quality and manner of their life and over the quality and manner of their final days. And society understands that there is this importance of a path to death that doesn't have to be overwhelmingly filled with fear and pain and angst. So you may imagine two grandparents, each approaching death, and one comes down with pneumonia, and the other is still suffering of their cancer. They're both approaching death, but one just happens to get pneumonia, and the one who's dying of pneumonia can tell their doctor, don't give me medicine, just give me comfort care. We all know that the time of my death is soon, and I am ready for comfort care. And this is an acceptable option. However, my other grandparent with cancer would not have such an option. And when we examine all of the methods of dying that I've already covered today about patients who stop dialysis or have their cardiac implant removed or seek comfort care or in a hospice setting, these patients wish they could live longer. They are not suicidal. They have overwhelming pain and angst at end of life, and they don't have any other options to help them. The method of stopping dialysis or going comfort care may indeed take days or weeks or months off of their lifespan, but this is currently considered morally and ethically justified. And as you can see, patients who request aid in dying follow all of these patterns as well. I struggle to see how aid in dying is immoral. It does require the ingestion of a medicine, but it's not the patient's fault that their body is breaking down in a method that only leaves them with the option to take and no option to forgo or remove. This is not an ethical or moral distinction. It's a technological and biological distinction. So as long as there are impeccable protections as proposed in this bill, and as long as data is collected to track what's happening, and as long as that data is evaluated, As occurs in other states, aid in dying is an option that would contribute to the moral landscape of our state, because we would then be offering a compassionate path for those who wish to take it.
Thank you so much, Lori, for that. We'll move now on to Steve Latham. You are muted. If you want to unmute yourself.
I've done that twice today. I think it's a new record. My name is Steve Latham. I'm director of Yale's Interdisciplinary Center for Bioethics, and I thank you so much for having me and for taking some time to listen to my point of view on this. I am a faculty member at Yale. I teach bioethics mostly to undergrads. I'm also on clinical ethics committees that do bedside consultations in the Yale New Haven Hospital and in the Children's Hospital. Before I was an academic, I was a healthcare lawyer representing physician groups and hospitals in business transactions, antitrust, Medicare payment lawsuits, and so on. I left that to get a little ethics training and entered academia. And my first position before I was on a faculty anywhere was as Director of Ethics Standards at the American Medical Association. I was also secretary to the AMA's Council on Ethical and Judicial Affairs. And at that time, which is just when Oregon was proposing what was then known as the physician-assisted suicide program, I was opposed to it. I had been persuaded by people like Judge John Noonan, who decided one of the early cases got overruled by the Supreme Court, but he decided one of the early cases around the Oregon statute that medical aid in dying was going to be offered disproportionately to poor people and people who were less educated and to minorities, instead of the hard work of good communication and better end-of-life care. I was persuaded and worried by that argument and therefore opposed medical aid in dying. I was really wrong about that. If you look at what has happened in Oregon in the subsequent 20 years, who uses the medical aid in dying program that they've had in place for all these years? It's predominantly educated people, urban dwellers, very, very few minorities, disproportionately few minorities have ever used the program. 90.5% of the 2018 population who took advantage of Oregon's medical aid in dying program were in hospice. 88.5% were in home hospice, and 99.3% of them were insured. So this has not been used on populations that are particularly vulnerable, and it completely coexists with excellent palliative care services and with much higher penetration of home hospice than this state has. This state has terrible home hospice penetration and very low hospice stay rates compared to the rest of the country. The overall point is, I changed my mind because the thing that I was afraid was going to happen did not happen at all. I want to turn now to address a couple of things that I heard when I was listening to testimony the other day. First of all, there's a lot of worry about the slippery slope. You know, if we pass a law like this, we'll sooner or later we'll start offering medical aid in dying to children, and we'll start euthanizing people who are clinically depressed, and on and on. That won't happen. Why am I so confident that it won't happen? Because it hasn't happened in any of the states in the United States that have laws very similar to the Connecticut law being considered in place. It just hasn't happened. And there are reasons why it hasn't happened. The slippery slope around here, if there is one, is you, the members of the legislature. Nobody's going to expand this law to cover children. It doesn't cover children now, unless you agree that it should be expanded to cover children. Nobody's going to change it to cover people who who lack mental capacity. No one's going to change it from self-administration of the drug to euthanization and administration of the drug by physicians. The places that have been plagued with a little bit of slippery slope are places like Belgium or the Netherlands, where they don't require terminality in the patient, and where the standard isn't terminal illness, but is unrelievable suffering or irremediable suffering. That leaves a lot more room for subjectivity on the part of the people who are actually enacting the law. In addition to that, they also permit euthanasia, that is to say, physician administration of the lethal medication rather than the patients simply taking the drug themselves. That also permits a little bit more of a slippery slope. In laws like in Oregon and across the United States now, those things can't happen without action by the legislature. And to the extent people are worried about a slippery slope, what they're saying is, we're worried that Connecticut is going to change this law. And I don't see that happening very easily. I want to make another point about the real similarity. Lori made this point a little bit in her presentation, but I want to say something about the real similarity between medical aid in dying and other approaches to aid in dying that we already have in place and that everyone is very confident about and comfortable with. I dislike the name medical aid in dying, in fact, because there are lots of ways in which physicians aid people medically in dying. If you think about withholding or withdrawing of care from someone who would prefer to die rather than to go on with an aggressive or an uncomfortable medical intervention, we often talk about using these medical interventions as doing everything. You know, doctor, I want everything to be done. And then we make the mistake of thinking that when a patient asks for, say, a ventilator or a feeding tube to be withdrawn, then what the doctor is going to be doing is nothing. To do nothing in those circumstances would be malpractice. Doctors who help patients have care withdrawn are actively engaged and involved in aiding those patients' deaths. If I say no, if I have ALS and I can't swallow on my own anymore, and I say no to further feeding tube, as is my right under current law, does the doctor say, I'm just going to let your disease take care of you now, and I'm not going to do anything? No, the doctor aids me in dying, puts glycerin on my lips to prevent cracking, gives me ice chips to prevent the thirst that comes with not having the feeding tube connected, right? Because we have this fake idea in our heads that doctors who withdraw care aren't doing anything to actively help the patient die more comfortably, it seems like some kind of strong contrast with a medical aid in dying circumstance, but it really isn't. There isn't really a doing allowing distinction at stake here. Still less is there much of a distinction with what we heard a little bit of testimony about, palliative sedation. A 2015 study showed that 99% of the physicians in the American Academy of Hospice and Palliative Medicine approved of palliative sedation. Something in the 80s approved of it for symptoms that were not manageable, and basically all the rest approved of it as a technique to ease dying when death was really imminent. This involves sedating the patient to the point where the patient cannot survive in that sedated state. It is giving a drug to the patient that will result in the patient's death. And 99% of physicians who do hospice and palliative care have come out in favor of it. So this is not that radical a step. As Lori said, the thing that really makes it distinctive is the physical condition of the patient who doesn't have a kind of care that can be removed carefully and with assistance to help them die, and instead is suffering with a disease that will keep them alive longer in a state in which they don't want to live. I heard a little bit the other day about the drugs being used in connection with these programs. There have been some bad experiences among patients who take the prescribed medications to end their lives. For example, in 2018 in Oregon, of 169 people who ingested medication, one person regained consciousness after having taken the medication and died of their underlying disease instead of the medication. So it's not perfect. There have been isolated instances. People cite numbers like 10% of the people who take the medicine have these problems. Those come from a study that was international and looked at all kinds of drugs being used in all different countries around the world. The number, again, the number that I think is the one that you can rely on most is that 1 out of 169 patients in Oregon in 2018, which is the latest year where they've published data, had an experience of waking up after ingesting the medicine. So it isn't perfect. That needs to be described in the informed consent process, but it is no more imperfect than any of the rest of medicine and any of the rest of the complicated business of trying to take care of people at the end of their lives. The last thing I'll say is that we've heard a lot about the potential for abuse of these medical aid in dying laws. And in particular, we hear concerns of the disability community, who have experiences frequently of being told that they don't have much time to live when in fact they go on to live for years, or being told by their families or by their caregivers that their lives must be not worth living, and so on. My response to this is that these concerns do need to be taken seriously. In particular, in the process of assessing the suffering of the patient, we should really try to make sure that there isn't a failure to address disability-related suffering that could be treated that is driving some request for medical aid in dying. But because of the safeguards we have in place, we don't really have any experience of this happening. We have 20 years of experience in Oregon, 21 now, and 20 more years of combined experience in the states that have adopted similar laws since then. And we just don't see this kind of abuse being reported or being litigated. It's just really not happening. The patient has to have a terminal illness. A physician has to have predicted death within 6 months, and the patient has to take the medication on their own. These are things that it's very hard to force someone to do. And of course, it's impossible to give someone a terminal illness. The last thing I'll say is, in connection with these worries about abuse, some people have argued that there should be a mandatory psych consult for anyone who wants to avail themselves of medical aid in dying. I think that's overcautious. It would raise the price of medical aid in dying enormously, and also make it more difficult by involving another physician in the consult beyond I believe the law has 3 who need to be involved right now, right? 2 who have to hear the requests. Well, it would involve another physician in any case, but also, more importantly, doctors make capacity determinations about their patient's ability to make decisions for themselves all the time. When a patient says, "Doc, I don't want any antibiotics for my pneumonia," the physician is making a judgment that that patient has the capacity to say no to that unwanted care. When a patient with ALS says, "I don't want to live on this feeding tube anymore," physicians exercise their judgment about that patient's capacity without needing to call a psych consult. I don't think there's one necessary here, because I think the other protective provisions of the law are more than adequate. And with that, I'll stop and look forward to questions at the end of the session. Thank you.
Thank you, Stephen. Appreciate that. Next up, we have Dan, if you're ready.
Yes, let's see here. Share my screen. Are you able to see the screen?
Yes, we are.
Great. Okay. So my name is Dan Diaz, and I am Brittany Menard's husband. This is my wife, Brittany. She died November 1st, 2014. Brittany was only 29 years old, and she experienced a gentle dying process only because of the option of medical aid in dying. Yes, my wife, this person that you see on the screen, 6 years ago, she utilized the very program that Connecticut is now contemplating. Just to provide context, Brittany began experiencing headaches a few months after our wedding. They would wake her up in the middle of the night. She'd start vomiting, be unable to go back to sleep. On New Year's Day, we discovered the brain tumor. This brain tumor. She endured an 8-hour brain surgery, and we researched every treatment option that was available. After the surgery, she was given a prognosis of 3 to 5 years to live. The pathology showed that it was a grade 2 astrocytoma glioma, for those of you keeping score. But unfortunately, just a few months after that brain surgery, the tumor showed signs that it was growing aggressively, indicative of now a GBM, a glioblastoma multiforme, the same cancer that killed Senator John McCain, Beau Biden, and Senator Ted Kennedy. By the way, they were only able to remove about 35% of that tumor. There are parts of the brain that they just can't send a scalpel into. So Brittany was determined to live as long as possible. So we moved from our home in California to Portland, Oregon, and her case received a lot of attention in the media. We moved to Oregon so that she could access Oregon's law. Had we stayed in California, the brain tumor would have continued to torture her to death. As the cancer continued to progress, Brittany's symptoms got worse. She was dealing with pain that not even morphine could alleviate. Dilaudid is 4 times stronger than morphine, and Brittany was on some pretty hefty doses of Dilaudid. There was the nausea, the vomiting, the inability to sleep for days on end. The seizures are what terrified Brittany the most. The small seizures would leave her unable to speak, typically for 20 to 30 minutes. When she'd have the full grand mal seizures where every muscle in her body is contracting, as she's coming out of those, blood's coming out of her mouth because she's bitten through part of her tongue. That's just the reality of what Brittany was tolerating. What was coming next, as the tumor grows and puts pressure on different parts of the brain, that would cause blindness. If she suffers a stroke, she'd be paralyzed. Dying in bed as basically a suffering mass stuck in her own body with tubes coming out of her. Brittany said, "I will not die that way. Why should I be forced to?" Once we were in Oregon, she then applied for, qualified for, and was finally granted the prescription. She put that medication in the cupboard and she focused on living life. I want to emphasize this. A person who applies for this, they simply have that medication. We had medications in the home that were just as lethal. But having that medication, having this program affords this individual the ability to focus on doing the things that matter to them with the time they have left on this green earth, because they don't have to be so concerned about how their dying process might play out. And I'd like to settle something that I've heard claims about. I'll begin by sharing the enormous gratitude that Brittany and I had for her medical team, but modern medicine cannot control an individual's pain and suffering at end of life in 100% of the cases, period. This is not a failure by the medical community. This is just reality. And any assertions made by anyone that they can control suffering at end of life in all cases, that is simply not true. This statement by the California Medical Association, as we were working on the legislation in California, I think kind of puts an end to that debate or that conversation. As it states, however, despite the remarkable medical breakthroughs we've made and the world-class hospice or palliative care we can provide, it isn't always enough. This statement was by the president of the CMA, Luther Cobb, and it was made back in 2015. So that paternalistic view of a doctor telling a patient when you've suffered enough and then hooking you up to a morphine drip as they die potentially a terrifying death. And you can ask me about terminal sedation, palliative sedation, because I've seen that play out firsthand as well. Brittany refused to accept that. The opponents on this matter, their campaign is based on fear. Their campaign is based on using inflammatory terms like suicide and euthanasia in order to attempt to scare legislators into simply going along with the status quo. I'm going to share with you the difference between what medical aid dying is and when they try to conflate this with suicide. So in the case of medical aid and dying, by definition, these people are terminally ill. They are dying. In the case of suicide, of course, that individual might not be terminally ill. They could otherwise continue living. They're suffering from depression, despondency, and those issues need to be addressed. In the case of medical aid and dying, these people are mentally capable. In the case of a suicide, as a society, if a person is looking to do harm to themselves, we would say that, well, they're mentally impaired. This point, very meaningful, because as this applies to Brittany or anybody who pursues this, these people want to live. A person who is contemplating suicide, they want to die, or they think they want to die. In the case of medical aid and dying, the ending is planned. In the case of a suicide, it is often very impulsive. In the case of medical aid and dying, the death is gentle. Within 5 minutes of taking that medication, Brittany fell asleep very peacefully. Within 30 minutes, her breathing slowed to the point where she passed away. In the case of a suicide, the death is often violent, many times with the use of a firearm. I've been to 14 different state capitals over the last 6 years working on this legislation. And so many times I hear from legislators who represent a rural district in their state, and they comment that, and actually this was a conversation I had yesterday with a senator from the state of Nevada, that for him, the ranchers that he deals with, the term he used is, yeah, Dan, in my district, these people, they simply take a lead pill, meaning they use a bullet. That's their solution. And obviously, that's not healthcare. That we should not have terminally ill patients get to the point of despondency where they think that that's the option. So in the case of Brittany, I was there next to her. Her parents were in the room, 3 of her friends, my younger brother, and Brittany experienced that gentle dying process. In the case of medical aid and dying, the patient is connected to the family and friends because they can talk about this openly. They can rely on their friends, family, working within their own set of spiritual beliefs. And by the way, I say this as a Catholic. I went to Catholic school. That patient can navigate their end of life in an open and honest way. In the case of a person who's contemplating suicide, these persons have to act alone, because if they speak up, if they share that with anybody, right now in the state of Connecticut, those family members, they can then be prosecuted as if for aiding in that person's death. And then lastly, and this is something that we need to change, and I spoke about this when I provided the testimony, we need to do better. Suicide, there's 44,000 suicides every year in this country. The biggest growing segment of that are men and women in uniform. I think we're up to it's 24 servicemen and women every day. The number's getting, I think it's 8 to 10,000 a year. And these are individuals who, unfortunately, they don't have the support that they need. And they view that as the only option that they have. And what I'm referring to here is, as far as that grieving process, for me, I miss Brittany every day, but I'm immensely proud of the change that she made in our society when it comes to talking about issues of end-of-life care and end-of-life options. We need to stop for those individuals who, unfortunately, take their own lives by suicide, that grief and that guilt and the shame that we as a society cast on either that individual or the family members. We need to do a better job of that. I've had countless conversations with those surviving family members, and it's terrible, the grief that they feel. So specifically now to the state of Connecticut, by a 2-to-1 margin, Connecticut voters support medical aid and dying. This is from a Quinnipiac poll 2015. The people of Connecticut deserve better than what Brittany got. No one should ever have to leave their home after being told that you have 6 months to live. Finally, support from the disabled voters. This is from a Purple Insights poll, February 2014. from the disabled community, because they're very vocal against this, but they are not a monolith. The people who show up to testify, they are extremely vocal, but they are indeed a minority. Here are just a few of those voices. This guy's name is Justin. He had Duchenne's muscular dystrophy. I think his statement sums this up the best when he said, it's not about people with disabilities. It's about people who have a terminal illness. It's your life, your pain, your treatment, your death. It should be your choice. Another one, this guy, Kevin Roster, I actually spoke to him. He moved from New Jersey to California so that he would have this option. He had sarcoma. Since my original diagnosis, he had endured rounds of chemotherapy, radiation treatments, off-label therapies. And for him, his statement, it has nothing to do with having a disability. The last surgery that he had, they had to amputate his left leg and basically his left ass cheek to remove this 20-pound tumor. He needed an electric wheelchair to move around. He says, it's not about being unable to walk and wheelchair dependent. I can deal with that. I still think life is beautiful and want to live every day as long as I can. But there's no reason anyone with a terminal disease should not have the option to avoid intolerable pain and suffering at the very end of life. Stephen Hawking, very famously, was supportive of this option. And lastly, only because it's been mentioned before, anecdotally, as far as the data, here's the proof. So this is from the Disability Rights Oregon. This is, and I'm going to read what this organization is. DRO is mandated under federal law to investigate complaints of abuse or neglect of individuals with disabilities, including inappropriate actions taken to hasten the death of an individual. I have these going way back. We get these every few years. We reach out. This is from the executive director. And this was the one from 2016, where the answer is no. DRO has still not received a complaint of exploitation or coercion of an individual with disabilities in the use of Oregon's Death with Dignity Act. The most recent one, which is this one, sorry for jumping back and forth, but I thought this, I very much appreciated that he included this at the very bottom here. And I'll send this over so that you can see this. DRO has received very few complaints from disabled Oregonians about the act. When I read that, I'm like, uh-oh, wait a second, very few complaints, that's not good. But then you keep reading. All of the complaints we have received have focused on the concern that the act might discriminate against persons with disabilities who would seek to make use of the act, but have disabilities that would prevent self-administration, thereby denying these persons the ability to use the act. So you see that the concern by the disability rights community, and as the data that I shared before support, that with 65% support, and to quote Dustin, that it's not about the disability. Simply having a disability does not qualify an individual for this program. You have to be terminally ill. And if a disabled person finds themselves in Brittany's predicament, they want to know that they also have this option for themselves. So with that, I thank you for allowing me to share Brittany's story, and I will stop sharing the screen now.
Dan, thank you so much for that. Really appreciate it. We'll move on now to Peggy. Are you there? While we wait for Peggy, because it doesn't seem like we can hear her, Dan, you had mentioned that you had experience with, and I forget the terminology, but essentially putting somebody into a coma. I know that I spoken with Lori a bit about this during testimony last week. Could you explain a little bit about what your experience has been with that?
Sure, and the easiest way for me is just to contrast Brittany's dying process with that of a friend of mine. Her name was Jennifer Glass. Jennifer Glass suffered from lung cancer. She had never been a smoker. Sorry, the emotion just comes up sometimes. So Jennifer Glass had lung cancer that had spread to her spine, her pelvis, and her brain. So at the end there, she was suffering from many of the same symptoms that Brittany was suffering from. I went to visit her. She lived in San Mateo, California, which is right in between Stanford and San Francisco. So she's receiving excellent palliative care at both Stanford and UCSF. This isn't a question of not having access to quality medical care. But Jennifer, once things progressed to a point where her medical team could not keep her comfortable, she was suffering from the seizures and everything else that Brittany was enduring. The only option for her was that of palliative sedation, terminal sedation. The terms are used interchangeably. So she agreed to that. They sedated her. She was sedated for 5 days. I went to visit her. It was the day she ended up dying. It was August 11th, 2015. And what I found was Jennifer in bed with tubes coming out of her. And her family for those past 5 days they're basically holding vigil, administering the meds according to the protocol that the physicians have laid out, keeping her sedated. Unfortunately, it's a little bit more of an art than a science. They know the patient weighs so many kilograms and they administer the protocol on a certain schedule. On 2 occasions, Jennifer starts coming out of that sedation, eyes wide open, arms flailing. They rush to get her sedated. By the time they do that, she's foaming at the mouth. I mean, it was terrifying for the family, but also the experience that Jennifer herself was going through. The question after seeing that, so in the end, she died that evening. And her husband, Harlan, summarized this the best, where he said, Dan, terminal sedation is the exact same thing as medical aid in dying, simply in slow motion. Why did Jennifer have to endure those 5 days? In Brittany's case, like I mentioned, she fell asleep within 5 minutes and stopped breathing. Her breathing slowed to the point where she passed away in 30 minutes. The end result of, and it's right there in the name, the end result of terminal sedation or medical aid in dying is death. Let me clarify this. They are not going to stop administering those meds to keep that person unconscious, and they were withholding food and water. They will keep administering those meds until that person dies. The end result is the same. So the question that I would have for any of you, legislators, think about yourselves, your family members. Would you at least want to know that you have this option amongst all of the options that are out there? All the clinical trials, hospice, palliative care, terminal sedation, but also that medical aid in dying would be one of those things that you could choose for yourself if you decide to apply for it. So that's the difference between terminal sedation and medical aid in dying, that, you know, for Brittany, she was able to look around the room, say, I love you to the people in her life, and experience that gentle dying process. For Jennifer, it took 5 days, and it was not, it was a promise that was unkept. It was not a gentle dying process for her.
Thanks, Dan. Looks like Peggy, are you ready?
I am.
Go right ahead.
Terrific. Good morning. Thank you for asking me to speak. My name is Peggy Coburn. I live in West Hartford, Connecticut, and I'm the administrator of McLean Home Care and Hospice in Simsbury, Connecticut. And I think my portion of this education session is to talk about the consumer and what is available to them to help them progress in these incredibly important decisions about life. And part of my job is I go out into the community and I speak with groups and senior centers and churches and libraries. And one of the presentations that I work on is called the Conversation Project. The Conversation Project is a public engagement initiative. It is a value-based plan that tries to help everyone talk about their wishes for their care through the end of their life, and to help them formulate these difficult conversations so that they can be understood and respected by the people around them. And the tenet, a major tenet of the Conversation Project, which is available to anyone who is interested, free of charge, and you can find it yourself at theconversationproject.org, and I go through the starter kit. And the tenet of the Conversation Project is to take these conversations out of the ICU and bring them back to the kitchen table. And essentially this workbook, and when I facilitate these meetings with folks, is you go through and they're prompts. I always give them paper. I give my participants a paper copy. This is of course pre-pandemic, and a pencil. And I tell them what you write today or tomorrow, do it in pencil because your thoughts may change. You may have different perspectives. But essentially it's a workbook that offers prompts to the user and it goes through the steps of trying to identify what brings you comfort in your life, what is important to you. I find step 2 of the Conversation Project to be most effective in that it's a series of prompts that have scales that are attached to them. So the prompt might be, as a patient, I would like to know, and the scale down below is either on one end of the scale, only the basics of my condition and treatment, up to the other end of the scale, which might be all of the details of my treatment. I want to know all the lab results. I want to know all of that. Another prompt is there if there is a medical decision to be made, the scales, one end of it is I want my healthcare team to do what they think is best, up to the other end, which is I want to have a say in every healthcare decision. Another prompt, if you are seriously ill or near the end of your life, how much medical treatment would you like? One end would be, I would like every available treatment to extend my life. And the other end might be, I would only want treatments that would be available to me that will impact the quality of my life in a positive way. It goes on with a series of other prompts. Would you like to die alone or with people? Where would you like to physically be? You know, one end of that would be in a healthcare facility. Another end of that would be at home. And essentially, this is just for the consumer to sort of figure out at first blush where they stand on these issues. And you know, the reality is there's 2 things we can't avoid in life, and that's death and taxes. And we do a lot of planning for things like taxes, but we don't do a lot of planning for the end of our life or talking about it or figuring out where we're going. So one of the things that I always do when I start this session with participants is I talk about my personal experience. And it's about my mother, Mary, who was an Irish Catholic woman who married her high school sweetheart in 1950. She went on to have 6 children, was a stay-at-home mom, and her life really turned out to be as she expected it would be. When she got married, she stayed home, she took care of things. Her husband, my father, went out to work until at the age of 56, my dad unexpectedly died of a heart attack. And all of a sudden, my mother's life changed. Now her world looked very different than the one it did in 1950 when she got married. And she had lots of decisions and responsibilities ahead of household. So one of the things that she did was she went and found an attorney, and she went to, thinking she went to draft her last will and testament. The attorney at that point said, there's this new thing, which is how she described it to us, called a living will. And when she heard what it was, she thought it was a great idea. They went through it. My mother did a couple different things with her living will that I would encourage anyone who's listening to consider and think to themselves about this. But she immediately went to the library and she made lots of copies of this living will. And she then gave it to all 6 of her children, all of her doctors, her sister in New Jersey. That's probably not so unusual, but the next thing that she did was after handing them out, was she talked about what was in her living will. What were her advance directives? What were her wishes? And as a child who had just recently lost her dad, I didn't always appreciate these conversations. I was younger, my younger self, but it was important to her. This was a direction for her children and the people who loved her. She would even, I grew up in Old Saybrook. We'd go, one of the things you do in Old Saybrook is you drive along the shoreline and you look at the sound, and there's a nursing home down there near the sound. And she said she would always, no matter who took her on the drive, point to that nursing home and say, if I can't take care of myself, that's where I want you to put me. I've heard from the ladies in the garden club that on the 3rd floor on the left-hand side, you can just glimpse Long Island Sound. That is where I want you to put me if I can't take care of myself. So fast forward 10 years and my mother has her own health event. And she was taken by ambulance to, we call it the Shoreline Clinic. It's in Essex. It's a satellite of Middlesex Hospital, where she was worked upon, and that my sister and brother and I met, arrived there. The doctor came out and said, I've done what I can do here, but I really would like to fly her up to Middlesex because I believe there's more that can be done for her. And it seemed like a reasonable plan. And then the doctor at the deep breath said, this will require that we intubate her for the flight. And all three of us, who as siblings don't always agree on much, but stepped forward and said, absolutely not. That was not my mother's wishes. She did not want to be intubated. She did not want to have a breathing tube. So a lot of conversation later, we struck a compromise that they would intubate her for the flight, and that when she arrived at the hospital, they would extubate her, take the breathing tube out, and then see where that took her. And it felt like a reasonable compromise to honor her wishes. Unfortunately, when they extubated her, she was not able to breathe on her own, and she did die. But I will tell you to this day, and at that moment, my other three siblings who were not with us, there was never a question amongst us of that we did the right thing or that we made the right decision. It wasn't even part of the conversation. We all knew exactly what my mother wanted, and we with fidelity tried to support those wishes for her. And I think that, for me, and listening to all this testimony is we evolve as human beings. If you were to ask my mother on her day of her marriage in 1950, would you ever imagine directing a doctor in the care for you? Would you ever question a physician's goal, or would you ever feel like, I think she would have said no. And I think we all evolve, and our life experiences, and certainly that was true with my mother, that she drew upon those to develop her plan for the end of her life. And I just wanted to share that there is this tool. There are many tools out there to help us all engage in these conversations. But it does allow for thoughtful conversation with those that we love.
Thank you so much, Peggy. I have a quick question for you. Being in the hospice industry, and we only have a couple minutes left, and I want to be respectful of everyone's time, so I will just have one or two questions, and then we'll be done. What have you seen in terms of thinking within the industry? I know that hospice has historically been, generally speaking, against aid in dying, and that there has been somewhat of a shift. Can you speak a bit about that shift?
Well, I'm always hesitant to talk in generalizations, and I may be not an outsider, but I'm a firm believer in choice. And from a hospice perspective, I personally really believe that as many tools as we can have in our toolbox, we are better served. And at the end of the day, this is about choice. And I think as having people who work for me in a hospice, our goal is always to honor the patient choice. So can I say that all my fellow hospice providers feel the same? I really can't because I don't know, but sure. That's certainly in my perspective.
All right, thank you, Peggy. I appreciate that. And not trying to nail you down, so I appreciate that perspective. And then my last question, I suppose, is maybe geared more toward Lori and Stephen, is finally just to say, hearing a lot about the slippery slope argument and comparisons between us and Nordic countries, would you be in support of a law that did not address end of life and really address, irremediable suffering? I can't remember the exact terminology you used.
I don't know if Lori and I agree on this, but I would be opposed to a law where the criterion was irremediable suffering. Because I think that the remediableness of suffering is going to be very difficult to determine. One thing that they do in the Netherlands to try to control that risk is they do downstream very heavy monitoring of all the cases. There are regional committees that get together and review the medical files of every case of anyone who has been euthanized or who has used medical aid in dying, taking the prescription themselves. But I still would be opposed, just because I think it injects a little bit too much subjectivity into the entire process.
Yeah, I would agree with that. I think that it is too hard to quantify and too hard to roll out in any sort of consistent manner, at least at this time.
Dan, I see you put your camera back on. You want to weigh in on that and then have the final word?
No, I believe that the safeguards that are in place are appropriate and should be there. The two physicians independent of one another agreeing this person is terminally ill with 6 months or less to live, mental competency. They make the request verbally and in writing. There's the waiting period. That's the one thing I would say that should change, and that's from the feedback we've gotten from all the states where we've introduced this, or where this is legislation stands, is that 15-day waiting period. It's a little bit too long. And I've spoke to the original authors of this in Connecticut from in Oregon from 23 years ago. And why was that put in there? They figured it would be prudent. And they figured that that would make it so that people could get a little bit more behind this. Let me put it this way. That 15-day waiting period, during that time, those cancer cells are not taking a break. Those cancer cells, if anything, they're not multiplying slower, they're multiplying faster. So in Brittany's case, it wasn't an issue. She applied for this early. She applied for it in May. She died in November. But I've had way too many conversations with individuals who, for them to get through that 15-day waiting period, that was a struggle and a concern. So is something like maybe 7 days more appropriate? I'm not, I don't want to, I'm simply sharing the feedback that I've gotten from these individuals. The 15 days, if that's what the Connecticut legislature feels is appropriate and should be in there, that's fine. I'm supportive of that. But I'm just sharing as far as any tweaks that could potentially, from the patient's perspective, that might be one. But what I'll just finish with what I was saying. The safeguards that are there, absolutely appropriate. And I get tired of listening to, oh, but here's what's happening in other countries and here's where things have gone. It's like, well, yeah, those countries also have much different laws concerning gun control. Over here, people can openly carry guns and use those guns to kill one another. And unfortunately, tragically, that happens way too often. So, do we make comparisons to other countries when it comes to the Second Amendment? You talk to a lot of people and they're like, heck no, we're not going to make those changes. So it bothers me when they'll quote the statutes of some other sovereign nation and try to say, well, that's going to somehow apply here. The law that we've passed in the United States, the safeguards that are in place, those are very rigorous. And I think that if Connecticut adopts this year, it'll be a very good thing for terminally ill individuals within your state, just to bring that peace of mind.
Great, thank you so much. Lori, Stephen, Dan, Peggy, thank you all so much. Representative Steinberg, thank you for your comments at the beginning, and let's see how it goes tomorrow.
Thanks.
Take care, everybody.